that the landlord, after telling you that you are filing a notice to quit and vacate his property for failure to pay rent, now owes you some duty other than to collect the rent from you, sounds bat crazy. That's crazy. You don't live in someone's house for free. You show me where you paid the rent or that you have a lawful reason, not some cockamamie story you didn't came up with. Your answer looked like you cut and pasted something from a probate court proceeding from probably a sovereign citizen, crossed out what you didn't think applied and signed your name to it. We don't run circuses in here. This is a courtroom of law. You understand me?
A tenant strolls into a Michigan courtroom 9 months behind on rent, and instead of an apology, he brings something wilder, a declaration of trust, claiming his landlord is secretly his fiduciary. Before we get there, he shows up late on Zoom for a hearing he was told required his physical presence. The judge, no nonsense, is already unimpressed. Landlord Eric Romano takes the stand. A $1,100 per month lease signed September 2023 with a $50 late fee after 7 days. Term by term, he confirms Zachariah Latney hasn't paid rent since August 2025, 8 straight months. A ledger showing $9,200 owed gets admitted over a shaky objection, and Romano confirms the unit was kept in good habitable condition.
Where are you on Zoom?
Present.
Why are you present via Zoom? You're supposed to be here in person.
Because I had certain matters that I was taking care of this morning, which unfortunately I just wasn't able to get completed. And I didn't know I was required to be there in person. I would have been there in person.
You definitely knew, because I say in person like a broken record when I give a hearing date. I do not hold hearings via Zoom. You must appear in person. The paperwork you received said you must appear in person.
Okay, so why was the plaintiff not required to appear in person, but I actually appeared in person?
The plaintiff is right here. The plaintiff is in my courtroom.
No, I was referring to the first date. The first hearing date.
That date was not a hearing. That date was a pretrial. Everyone could appear via Zoom for the pretrial. I said for the hearing, you must appear in person. Today is a hearing date. You're not here.
How does the court plan to resolve that then? Because
I don't. It's how you're going to resolve it. Because if you don't appear, I have to give them a default judgment.
So who are you talking to that's appearing now then?
That is the attorney. This is the attorney for the plaintiff. Where are you, sir?
You don't see me, man?
How long is it going to take you to get here? Yeah, how long is it going to take you to get here?
Give me 10 minutes. I'll be there.
Thank you.
Yep, I'll be there in 10 minutes. Don't worry.
This is E3 Investments LLC versus Zachariah Latney, 26-01434. Appearance, please.
Attorney Catherine Gable, P81555 on behalf of the plaintiff.
Your name, sir?
I believe the caption is Zach Latney.
It says Zachariah. Okay, your name's not Zachariah?
As it appears in the lease, it's Zach Latney.
No, I don't know. I'm asking if what was filed is correct.
Yeah, Zachariah.
Okay, thank you.
And as to court costs, Mr. Romano, is it correct that you would be seeking those costs in the judgment today?
Yes.
Okay. And no further questions, Your Honor.
Do you have any questions for the
Yes, Your Honor, I do.
Proceed.
Allow me a second.
Okay.
Can I get my questions together? Is that it?
No, I just told you can
Oh, no,
cross
it
examine
seems
the
like she had a complaint. I'm just like this issue. All right. Okay. What date did okay? This is gonna be my question. What date did you allegedly engage in the lease with the plaintiff, Mr. Romano?
He is the plaintiff.
With the defendant, Mr. Romano. Excuse me.
Jack has asked and answered, but go ahead.
He has answered that already.
The 22nd of September, 2023.
Okay, these proceedings, on what date did your attorney file the complaint initiating these proceedings?
I don't know. I can refer that question to my attorney.
So I can take judicial notice of when it was filed. I have it.
It
was filed with the court, it looks like on February 20th, 2026.
Okay, February 20th, 2026?
Correct.
Okay.
Actually, February 23rd is the stamp on the side, but it was dated by the attorney February 20th, 2026.
This action was filed?
That's when the complaint was filed.
Thank you, Your Honor. I do have more questions on point, which are okay, I wonder for the record, is your phone number, Mr. Romano?
But you don't have to put it on the record. His phone number. You can ask the last 4 digits if you want to confirm.
Thank you, I appreciate it. Is the last 4 digits of your phone number ended 9908?
Yes.
And did you text the defendant regularly for means of communication by way of payment to be received from you, from the tenant?
Yes,
So you and the tenant regularly texted with that phone number ending in 9908.
yes,
Okay. Prior to initiating this suit, did the tenant text you respecting amounts owed and that were paid to you?
I'm sorry, can you repeat your question?
Prior to your attorney initiating this suit, prior to counsel initiating this suit, did you and the defendant communicate regularly by way of that phone number ending in 9908?
yes.
Thank you. Okay. No last question. A few more questions, Your Honor.
Take your time.
Thank you.
Latney's cross-examination turns strange fast. He grills Romano on old text messages, a supposed background check, and whether a social security number was ever collected. Romano repeatedly says he doesn't recall. It was years ago. Then Latney drops a bombshell question. Was Romano aware he'd been expressly appointed as trustee back in March? Romano flatly says no. The judge steps in more than once, reminding Latney that not remembering isn't evidence of anything and that he'll get his chance to testify properly.
No, you don't. If you want to tell me all that during your testimony, we'll allow.
I don't
you
know
to
if he doesn't remember unless I ask, Your Honor.
I get it, but him remembering or not really has nothing to do with whatever point you're trying to make with that.
Well, if he said he remembered, it would actually affirm the point I'm making, is what I'm getting at.
Okay, well, he said he doesn't remember,
No problem.
and you're trying to re-ask him in another way. He's not going to change his question
No problem. Okay.
or his answer.
That's the witness, Your Honor. I'm done.
You can redirect if necessary.
Your Honor, redirect is not necessary. Thank you.
Any other witnesses?
No, Your Honor.
Thank you. You want to give testimony, sir?
Yes, Your Honor.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, I do, Your Honor.
Thank you. Tell me why you believe you don't lawfully owe rent since September of 2025. I'm sorry, August 25, or is it? Well, I guess it's when it's September 25th of 2025. Yeah, but the testimony was you have not paid rent since September 25th of 2025.
Yes, Your Honor.
So tell me why you lawfully can withhold rent, or why you believe that.
Well, first and foremost, I would direct the court's attention to the answer, which is on file.
You have to tell me your reason. I've read your answer, but that's not evidence.
Okay, no problem. I'll give you. Okay, so on March 15th, let me give you the whole layout since I'm on the record and I can get it all out. Right. You get it all out, and I'm going to testify. I'm giving my testimony right now. So prior to engaging in this lease with Mr. Romano, he required, and I have text messages to that effect, which he's received, he's read, but it's okay. I have text messages to that effect between me and him, wherein prior to engaging in this lease, he specifically required a social security number. And in requiring said social security number, it was for the purpose of a credit or background check. Said social security number was reflective of the principal obliger on the lease. This is antecedent to the lease that is signed and in the record and accomplished in her complaint. Okay. Said social security number that was taken from him is not reflective of myself. It's not reflective of myself with respect to being obligated regarding the same. This is just a primary claim that I'm making. I have a secondary claim, which is an equitable defense, which is layered onto this. Just bear with me. I'm not important.
I'm listening.
Thank you. I appreciate it. He was noticed of suretyship and subrogation rights with respect to the social security number taken and reflective of the principal obliger on the lease. He was noticed of a legal distinction being made with respect to the principal obliger and myself, as a matter of fact, by way of documentation provided to him in these text messages. Not only,
are you saying that was the nature of the text messages you sent in March?
Yes, Your Honor, I am. That's precisely what I'm saying.
Okay.
Actually, these text messages go back to February. Secondarily, with respect to the suretyship and subrogation claims, to which I stand as subrogate to the principal obliger underneath the lease, to whom I stand as subrogate with respect to the principal obliger on the lease. Him being the creditor or the subrogor, he was noticed that my suretyship and subrogation rights were transferred to him in trust for my sole benefit. What I am saying is, prior to even showing up to that first hearing 2 weeks ago, he was noticed of and read text messages wherein he was expressly appointed as a trustee and owes me fiduciary duties as sole beneficiary prior to initiating this suit. That is my purely equitable defense that I'm asserting here today.
Okay.
As a result thereof, and as a result of those allegations of fact, which bear on this immediate case, Mr. Romano and E3 Investments LLC, by way of a trust indenture, which I can show this court and my phone number, stands with respect to me as my trustee. And he owes me a duty of undivided loyalty as my trustee, as is my allegation of fact today. And I am the sole beneficiary with respect to that trust that I can provide the court. He owes me fiduciary duties and a duty to account with respect to that which he was entrusted with. specifically and prior to engaging in these proceedings. And he was noticed of that. Not only that, but as sole beneficiary, equity regards me as the true owner. And my sole defense right here now is that he stands in relation to me as a trustee and a fiduciary, owing me duties sacred in equity, to which I can't freely enforce in probate court. And as this court has been made aware of, this court doesn't have jurisdiction over those exclusively equitable claims of beneficiary of trust relations. But that is my equitable defense that I'm asserting here today, that he was granted a fund in trust, that he possesses said fund, and that as fiduciary, he owes me a duty to account as sole beneficiary. And that said accounting that he owes me directly conflicts with the legal relations that he has as landlord in this underlying suit. And I am now asserting there is a conflict and variance between the rules of equity and the rules of law with respect to the same matter. And that owing me an exclusively equitable duty of trusteeship.
That said, he owes you a duty of trusteeship?
Yes, he does.
Okay. Any other argument for why you think you can live in his property for free?
He's been granted the fund to which he must account. These are equitable rights.
You granted him some funds?
Yes, I granted him the
Where?
fund. But wait, I'll show you right here. Got you right here, Your Honor. Got you right
Show
here.
his attorney where the funds were sent to her client.
Is the court saying, as a matter of fact, that he's not?
Show me where you're going to show me evidence where you sent him the funds?
Yes.
Show it to the attorney first,
Thank
where
you.
he would send his funds.
Got you right here. Got you right here. Give me 1 second. I'm just pulling up the text. You're gonna see it says red right next to it too.
If this case already has you hooked, you're in the right place. Like and subscribe to Court with Mia. I cover the most epic, jaw-dropping court cases you won't believe are real.
For clarity, Your Honor, if I may, this is rent payments for the
Correct.
money we're claiming due and owing.
Those are the only funds
Not-
I'm looking at.
Not previous. Correct.
So, is
Just
this
for
court
clarification.
asserting that I did not have that equitable defense asserted is not
I don't.
relevant?
Well, let me be very clear here. I read your answer and I gave you ample opportunity to make a record here. I don't really know if there is an underlying issue that requires a competency evaluation, or if you Googled something that made you think that these things were lawful reasons to live in someone's property and withhold rent. You speak over me, you will be remanded for contempt in court. I don't know what's going on, but none of the things that you say or have said in this courtroom as it relates to a lawful reason to withhold someone's rent makes any sense. For you to sit here and vehemently assert that the landlord, after telling you that you are filing a notice to quit and vacate his property for failure to pay rent, now owes you some duty other than to collect the rent from you, sounds bat crazy. That's crazy. You don't live in someone's house for free. You show me where you paid the rent or that you have a lawful reason, not some cockamamie story you didn't came up with. Your answer looked like you cut and pasted something from a probate court proceeding from probably a sovereign citizen, crossing out what you didn't think applied and signed your name to it. We don't run circuses in here. This is a courtroom of law. You understand me?
May I respond?
If you have proof where you paid rent, show it to her. Otherwise, judgment for the plaintiff.
Your Honor, may I respond?
Do you have proof?
I'm trying.
Do you have proof?
You asked me to do two things.
Well, ask you one thing. Ask you one thing. Do you have proof?
Yes, I do.
Show her the proof.
Got you right here. I was in the middle of getting that earlier, but
No, listen here. Listen here. Show her the proof because she wanted to clarify what you were about to show her. Okay. I don't want to see no text messages of no. I notified him of some trust. That don't work here. We're not dealing with trust. We're not dealing with probate. We're dealing with possession of property. You signed a lease. You signed a lease. You agreed to pay the money. I don't care if he did a background check or if he didn't. Well, I don't care if you gave him your social security number or if you gave him your telephone number. You agreed to pay this rent. You've been holding over his property since August of 2025. And I want to see proof that you either have a lawful reason to withhold it or proof that you turned it over and he's just mistaken.
Okay. My mandamus gonna go in tomorrow too. Don't worry.
You can find a mandamus or anything else you want to find. I really do not. I promise you, I don't care.
Okay. So it's a quite lengthy text. That's why I'm trying to find it. But I'm.
Is this evidence of you sending his past due rent?
Yes, he's in possession. Okay. He's in possession of it. Yes.
You can show the attorney for her review.
Yes, 100%. And I'm standing on my equitable defense regardless. What are you reading right there?
It says declaration of trust and appointment of trustee. There's no
judgment in favor of the
Thank you,
plaintiff.
Oh,
you can be excused. Bye. Bye.
Yeah, I know. My mandamus going in too.
File whatever you want.
Yeah. Yep.
You have paperwork.
I do, Your Honor. The Possession 427.
The writ date
Yes.
is the 27th.
Thank
That
you.
is correct.
And do you need to prorate rent on the record or amounts due for the money
Yes, please.
judgment? Okay, for possession, Your Honor, he owes $8,800 in rent, plus $400 in late fees, plus costs in the amount of $174.80, for a total of $9,374.87. And for the money judgment, Your Honor, which has been prorated through today at $36.67 a day. Rent plus late fees is $8,870.07, with costs of $174.87. Sorry, yeah, it's $174.87, for a total of $9,044.94 for the money judgment.
Thank you.
You're welcome.
Any additional matters for the record?
No, Your Honor.
I think I've turned a recess of 5 minutes.
A trust document with no legal weight, a landlord who never agreed to any of it, and nearly $9,500 owed. The math never lied, even when the story kept changing. I'm siding with the judge on this one. She gave him room to speak, then ruled on facts, not theatrics. Was she too blunt or exactly right? Let us know in the comments. That's a wrap on another epic case, and honestly, I have so many more where that came from. Drop a comment and tell me what you thought, and make sure you're subscribed to Court with Mia so you never miss the next one. See you there.